Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. And not just a YouTube show. When you know, cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hey, welcome back. Welcome back, my friends. Thanks for coming to hang out with me today. Today is the Monday, July 7th, 2025, and we're going back to Norfolk Superior Court today for the hearing of Aidan Kearney, aka Turtleboy, because now the Karen Reed has been freed. It's time to free Aidan Kearney. The link for his defense fund is in the show notes below. You'll have to close out of the comments or the chat to get to it. I think what I can do is probably pin it in the chat for now. If you would like to donate to his defense fund, he's being represented by Tim Bradl and friend Mark Bederow, who you know very well, as I do. Aidan said that WBZ is going to be the pool camera in the courtroom, but that does not mean that they are going to be covering it live. There are 6 other cases on the 2 o'clock calendar for Judge Doolin in the main courtroom. And so I've got the Zoom feed up, and I just don't know if anybody is going to be actually streaming this actually live on YouTube or on their website. But I have WBZ up. You can let me know if you guys find it somewhere else. But the host has joined the Zoom meeting, so at least we got that. If nothing else, WBZ could be there, but they could just be taping it for later. I don't know. I'm not talking about other creators that are streaming it, because everyone and their mother is streaming it today. I'm talking about a clean feed that I can stream, because I can't stream another person's stream because I don't do that. I need this stream from Law and Crime or Court TV or WBZ. We're just going to watch the Zoom. Okay. You just saw Bederow walk in with Aidan. Okay. It's reported as a pool camera. Correct. But unless any of the usual suspects are streaming it on YouTube, whatevs. We don't talk about other creators in the chat, so we don't have to. WBZ, it may be in the courtroom, but I've got their live feed up on their website. And they don't say they're going to be covering it. They may be taping it and putting it out there later. But if you find out, you let me know. And I've got all the feeds up too, so we will see. Court TV was talking about it. Most lyrical FU of the day. Well done. Well done. Well done. I'll put this up here for now, just so that you know that it's here and you don't get nervous. But there are 6 other conferences on for 2 p.m. So I don't know if they're going to take the 6 cases before they take Aidan's. I just don't know. A pool camera is, we do that in New York too. Usually there's a pool camera, like a still camera and or a feed, and everyone else has to use their feed. It's to prevent, 7 networks from wanting to come in with all of their cameras. Yes, we covered that this morning, that Yuriy was rehomed. Yuriy was rehomed. He absolutely 100% was rehomed from Norfolk County District Attorney's Office. It was effective yesterday, but they signed off on it on the 1st. So that's interesting. They initially said he had been reassigned to the South Boston Barracks, but later provided an update saying he was transferred on a temporary duty assignment to the Division of Standards and Training. As a sergeant assigned to the Division of Standards and Training Commander's Office, they said he will perform, quote, a variety of administrative functions in support of the division's daily operations. Applications are now being accepted for the vacancy for the sworn sergeant position in the district attorney's office. So if anybody is a sergeant and you're looking for a job, you can apply for the job at the Norfolk County DA's office that Yuriy Bukhenik has just left and or been reassigned to. We also did talk about this morning when we were doing the Brian Walsh stuff that Kelly Dever may be on a leave of absence since late June. And so there's that. Yuriy has been rehomed, effective yesterday. But, I'm sure he's still making his hefty salary well into the 6 figures. And, there's all that good stuff. Yeah, right now, why not back to parking at the airport? Great point. Free Turtleboy. Oh, that's what I was going to do. That's what I was going to do for you. I was going to put the defense fund link and pin it in the chat. So let me do that. Somebody said they just saw that Mark and Aidan went into the courtroom. And so we have, as you can see, the Zoom feed up. And we're just waiting, still waiting, still waiting. I'm pinning Aidan Kearney's defense fund in the link in the chat. And it is currently a little shy of $200,000, and they're trying to get to 200K. It's at 193,995 for posterity. So let me get back and try and find my comment now so I can pin it. Wait. StreamYard changed their whole format. Everything is new today. It's giving me anxiety. And that is not what I meant to pin. So let me unpin that and try and pin my own message. But see, when I try and touch it with my finger, then it just sends me to the give, send, go. I don't think there's a way for me to pin it. Oops. From StreamYard. Everything is difficult today. I don't know. Is Mercury in retrograde? Norfolk County, where everyone goes to be rehomed, says Wilma. So true. Let's see. Can I pin it? No. The only thing I can do from inside of StreamYard is delete myself or ban myself, but I can't pin my own comment. Isn't that great? Anyway, here it is. Here's the give, send, go. It's also in the show notes below this video. You can find it there as well. He can use all the help that he can get because he's out there defending our constitutional rights. The give, send, go says, help Turtleboy defend free speech. Aidan Kearney is an award-winning journalist who has uncovered and reported on the cover-up of John O'Keefe's murder and the subsequent framing of his innocent girlfriend, Karen Reed. While the rest of the mainstream media has chosen not to ask questions directly to the conspirators responsible for John's death, Aidan has repeatedly asked them tough questions in person and held peaceful protests in Canton to raise awareness about the cover-up. From having the audacity to speak out against corruption and murder, the state police and the district attorney's office charged him with 8 felony counts of witness intimidation. The message was sent loud and clear. If you exercise your First Amendment rights and expose police corruption, they will send men with guns to your house to arrest you in front of your children's school bus. They did do that. The Commonwealth will be throwing everything at Aidan in an attempt to silence his voice because he's too effective. He needs aggressive experience and competent representation. To that end, we urge you to donate what you can to the Legal Defense Fund, which will go towards expenses related to Aidan's legal defense, including legal and expert fees and costs. I believe there are 10 felony charges remaining. 6 of them were dismissed. We went over the decision on the motion to dismiss. And if you believe in the Constitution, as Sherry Louise says, we believe in Aidan and the Constitution. Free Turtleboy. Praise be under her eye. Thank you, Gidget, for becoming a member. 77 is our 9/11 in UK. AK to get charges dropped. Thank you, Stephanie Flynn, for your super chat. He faces, I know, 105 years. Thanks, Diane, for your super sticker. Betsy, thank you for the 20. Keep doing you, Mel. Love you. Oh, I love you more. I love you more. Oh, Astro Stephanie says Uranus moved into Gemini today. Though, that is a big deal. See? I knew something was off with me today. Mike from Providence. Mel, I've missed your face. And Free Turtleboy. Oh, thanks for your 10, Mike from Providence. Although you don't claim DiPetro, do you? See? Astro Stephanie is telling us Uranus moved into Gemini today, though that is a big deal. Uranus? Do you call it Uranus? Yes, Kathy is here. She's praying for Aidan and his 2 attorneys. So many shenanigans, tomfoolery, and ballyhoo going on in all of these cases. And we just looked at the Brian Walsh case this morning at length. And it's a mess. It's a mess. Got Brian Walsh on video buying all sorts of things and stuff that could be used to clean up a crime scene. All of the things that he searched about in his Google searches. But there's a motion to suppress all of that evidence because Massachusetts State Police did not abide by the consent order to consent his phone for only communications. And they instead got his Google searches and his locations and things like that as such. So will that alleged killer go free? Based on the sloppy job of the Massachusetts State Police. Same players. Different game. A year after Karen Reed. And Karen Reed's case is what blew this all open. And Aidan Kearney's case is showing us just how selective the prosecution is of the witness intimidation statute in Massachusetts. Because remember when Mark Bederow wrote one of his famous letters to the district attorney saying, Chris Albert is illegally wiretapping people outside his pizzeria? Oh, here we go.
Yeah.
Free Billy Tibbetts. Gotta be muted.
Yeah.
I can hear people saying good morning. Just want to make sure I'm muted because remember that free Billy Tibbetts thing that happened during one of Karen Reed's hearings with Judge Cannoni. Oh, Linda Kenny Bodden just shouted me out and said to follow me. That's very sweet. She's married to Michael Bodden, who is one of the best expert witnesses on the face of the planet. He's been around as a forensic expert since OJ and before. Like, Michael Bodden is very highly regarded. In fact, Michael Bodden was hired by Shannon Gilbert's family in the Long Island serial killer case to show that she was strangled. Big deal. He's a really big deal. And she's an attorney. She's got a channel too. And that's amazing. I'm so happy. That's very nice. Thank you. It's Donna. Daily Dose of Donna.
Are you ready?
Hi, Donna. I'll come on your show.
Oh, do we have a Spanish interpreter? No.
Emails
We do
below
have a Spanish
my show
interpreter?
notes. I think I sent it to you also.
Okay. He's coming out any second.
We only have one still, one here. On my left hand, no, only one still, one here.
It's Judge Doolin
He's gonna have
today
more
in the
than
big
one
courtroom.
still. He's allowed to film, Judge Doolin.
He's allowed to film, she said. Judge Doolin. It's Margaret, the court clerk. How do I know these things? So smart.
Afternoon.
Who are you?
Good, I'm just trying to find two people. Oh, we do have a Spanish interpreter. Are the parties ready on the 58A of Zepeda?
Yeah, there's 6 other cases on. This is the issue.
Good afternoon. How you doing, Mr. Doucette?
Very good, Your Honor.
Good, nice to see you.
Jaeger, she's a B.
How are you?
These are the hearings that are going to happen apparently before this one.
Who also fluent in Spanish, but we did order a Spanish interpreter.
And Madam Interpreter is present. Number 15 on today's list, 58A of Albert Zepeda Sepulveda.
You're going to hear a whole lot from
I
other
apologize for
cases.
that pronunciation. He is in custody, will be brought in momentarily.
What number is this? 15?
Just because WBZ has the
Mr.
pool
McCracken.
camera doesn't mean they're doing
Good
it
afternoon, Your
live.
Honor.
They might be
The parties-
recording it and they might drop it
Madam
later.
Interpreter, have you been sworn today? Good afternoon, Your Honor.
Oh!
It's Judge Doolin
If the
today.
parties could please identify themselves for the record.
Judge Doolin.
Good afternoon, Your Honor. Keith McCrae for the Commonwealth.
Afternoon, Your Honor. Francis Doucette for Mr.
Not his
Zapata
hearing yet.
and with interim Bianca Jaeger.
Can I see the papers?
Good afternoon, Your Honor. Bianca Yeager, 303.
I am muted.
Nice to see you.
I am muted. Thank you, though.
Is there more for the district court record?
Yeah. You don't have probation, I don't think.
She was just here.
Yeah.
The public can go in, but I think there's only 90 people, I think, who are allowed in. But they didn't turn their camera on. One day I was not even streaming his hearing because I was streaming Karen Reed, and somebody who was on the Zoom for Aidan Kearney had me playing in the background. And so everyone was texting me. They're like, Melanie, you got to go on mute. We can hear you in the courtroom on the Zoom feed. And it wasn't me. It was somebody else streaming me while they were listening to the hearing on their Zoom. And it was so, I mean, it wasn't embarrassing for me, but people were telling me, you got to mute, you got to mute. And I'm like, what are you talking about? I got to mute. I'm not even there. It's crazy. Well, thank you, Jess is tweeting. Thank you very much. We're hanging out today. We're hanging out. We might have to listen to a couple other hearings. But, you know, we're here. We're doing the things and stuff. Supporting the people that deserve supporting. I know it literally wasn't me. Someone alert Shaggy. I know. Shaggy.
All parties are present.
This is not Aidan's
Okay.
case yet.
Before we begin, Your Honor, does the court have a copy of the police report?
Yeah, I got it. I just read it.
Oh, all right, very good, Your Honor.
Mr. McCrae, tell me about the case. Got 90 grams of coke and supposedly a warrant from California.
90 grams of coke.
In
Not
addition to that, the Quincy Drug Control Unit was setting up surveillance.
90 grams of
They
coke is
noticed
a lot.
that this particular meeting happened in the parking lot of Father Bill's, which is a shelter in Quincy. And once they were, when
We'll just see what else is happening in
one
Norfolk
thing that
Superior.
the
90
Quincy,
grams is a lot of
Quincy
coke.
DCU does whenever they can is when they see a deal like this, when the parties separate, one group follows the purported buyer, one group follows the purported seller.
Yeah.
They did get confirmation from the buyer as to what he bought and how much he paid, and after that, the defendant was stopped. There was a canine alert to his crotch area. However, there was no drugs recovered from his person. However, there was
90 grams of coke is a lot, right?
Underneath the, I believe underneath the passenger seat of the car, and also there was discovery in the search of the vehicle. There was a sock.
Apparently there was 100
And that's
people outside the court
inside
today.
the sock was the remainder of the drugs.
Tell me about the California warrant. Is that him?
Oh, he's got a warrant in California, this guy too?
At this point, I don't know, Your
Problem.
Honor. The police report indicates that a agent from Homeland Security reached out to the Quincy Police saying that there was a warrant for trafficking out of California.
Oh, for trafficking.
I
Dang.
even checked with
Move out of
with
Norfolk
the
County, guys.
drug control unit today.
It's not Turtleboy
I
yet.
asked them if they ever received the warrant.
We're listening to the other
They
case.
said they never got the warrant from HSI. I tried to reach out to HSI today as well, but I do not hear any response from them.
Okay.
Look at Brian Jr.'s
And
frozen
I don't know,
donuts.
based on the review of his III, at the
First of all,
very
great.
least, there's a,
Second of all,
there was a removable
ask the cop what
alien
happens to the other
charge
10 grams.
against
Nobody
him
buys
from-
90, they buy
I
100
think from
grams.
2022.
Okay. All right. Mr. Doucette.
California warrant appears to be total fiction, Your Honor. I will let Ms. Yeager continue
California
with
warrant is
the,
total fiction.
Yeah,
Your
go right
Honor.
ahead.
Sure.
Thank you. Good afternoon, Your Honor. When considering the factors in the statute, it is clear that the prosecution
I
cannot
love her
possibly
accent, this
meet their
lawyer.
burden in this case. As Your Honor very well knows,
Loving
there's a
it.
presumption of innocence here in these types
Hearing is
of
a status
cases,
hearing,
and there's
but we
a
don't
higher
know. We
burden
don't know
on the
what could
prosecution
happen.
of proof
So many
for
things
clear
could
and convincing
happen.
evidence.
Tell me a little bit about him. What does he do? Where does he live? What's his status?
All right.
Tell me the whole
Now
thing.
tell me this. If I
Certainly,
share this
Your Honor.
tab
Mr. Zapata
instead,
lives in the area. He has no prior criminal history record in Massachusetts or any other state.
Where does he live? Or who does he live with?
Mr. Zapata had been staying previously in Lynn, I believe.
Okay.
My apologies, Your Honor. And
can you still hear that audio if I switch to this tab? Because we're not listening to Aidan's hearing yet. So his hearing is for a status conference today. I understand WBZ has a camera in the courtroom. It doesn't mean they're broadcasting it live. If anybody can prove to me that they are, we can get off the Zoom. Jess Machado is there. Follow her on Twitter at Jess Machado Show. Good afternoon from Norfolk Superior Court for a hearing in the Commonwealth versus Aidan Kearney. A long line outside of supporters waiting to get a seat inside the courtroom. You can all follow my live in the moment updates here. We love Jess Machado. She's out there doing the Lord's work all the time for all of us. There's other hearings going on right now. Don't worry, we'll get there. She says there's about 100 people there outside. You might see some people you know there. But they just entered the courtroom 1 minute ago. Cosgrove is here, but I have not seen him yet, says Jess. Long line of supporters waiting to get a seat inside the courtroom. Going to have live in the moment updates. And there were over 100 people waiting to get a seat. The case is being heard inside the main courtroom inside Norfolk Superior, where Karen Reed's trial first started but was moved. That's the big one where they did the jury selection, right? This is interesting. Let's go back to what's happening in the courtroom.
somewhere around 10,000.
This guy had 90 grams of coke on him.
$20,000 cash bail.
20,000 cash bail, says Judge Doolin, for this guy.
Mr. Zapata
Surrender
also,
his passport within 24 hours of release.
He's going to have to surrender his passport.
We have
Brennan
an
is
next date
there?
of July
Is it true?
17th for probable cause.
right.
Quincy Court, Your Honor.
Sounds good. Thank you. Nice
thank
to
you,
see
Your Honor.
So, sir,
Love that
after
attorney's
hearing, the court
accent.
ordered you to recognize in the sum of $20,000
Yes,
cash
Kelly Dever is out on leave
with
since
the
June
following
23rd, and Yuriy
conditions.
Bukhenik has been rehomed. We know
Surrender
all
your
the things and
passport within
stuff.
24 hours of your
Thank you,
release.
Bethany Frankel. That's Bethany Frankel's
Consent to that condition,
line.
sir?
Doing the Lord's work out here.
Thank you.
Yes, thank you.
Thank you.
You're hereby notified if you charged with a crime during the period of your release, your bail in this matter may be revoked in
Yeah,
accordance
this
with
guy,
Mass
9
General
grams of
Law,
coke,
Chapter
20,000 cash bail.
276, Section 58.
Do not pass go. Do not
Thank you,
collect
sir.
200.
Thank you, Your Honor.
Thank you. Have a nice day.
Your Honor.
Nice to see you.
Lockup's coming in.
Mr. McCray, always a pleasure.
2,000. Thank you, Elijah.
Take care.
Good to be back.
Are we ready
Good to be back.
on the Kearney matters?
Oh, the Kearney matter. Here we go. We're just getting
This one.
audio. That's the way it
we're gonna
is.
do
They'll
Mr.
do the
Kearney.
video later, I'm
So
sure.
next before the court, number 6, 7, and 17. Number 6 and 7 are on for status. Number 17, which is 25 CR 88, is on for arraignment. So please come forward and identify yourselves for the record.
Good afternoon, Your Honor. Robert Cosgrove for the Commonwealth.
Good afternoon.
Hello, Your Honor. Timothy Bradl on behalf of Aidan Kearney. To my left.
Good afternoon. Good afternoon, Mr. Kearney.
And Mark Bederow for Mr. Kearney.
Hi, Mr. Bederow. Good afternoon. Okay, let's arraign him on the new case.
Arraigning on the new charges.
Mr. Kearney, on May 13th of 2025, the grand jury sitting in the County of Norfolk returned indictment number 2582 CR 00088, charging you as follows. Offense 1, charging intimidation of a witness And offense 2, charging intimidation of a witness. Do you wish to waive the formal reading of these indictments?
Yes.
How do you wish to plead to each of these indictments?
Not guilty.
Thank you, sir. Is there a question of bail?
There's no question of bail, but I would ask the court to impose the same conditions that were imposed in the Stoughton District Court. And Mr. Bradl, correct me if my memory is wrong. I believe it was no contact with the alleged victim and stay 100 yards away from his place of work and residence.
And what are the allegations on these, on this one?
Intimidation.
Intimidating
of
a
the witness,
window.
Your Honor.
Yeah, but what's the nature of it?
This was
The
the
window
appearance outside.
Oh, outside the, waving in the pizza shop.
at the
Yeah, I
DNA.
remember. All right, that's,
Judge, that's agreed under Section 87.
yeah, that's fine. All right. I'll
No, this is
impose that,
something else
Margaret.
too.
Thank you.
Would you like me to do that now or wait till the end?
Why don't you do that now? Just do them one at a
All right, the
time.
court recognizes you personally without surety with the following conditions. You are to have no contact, direct or indirect, with the victim in this case. And you are to stay away, have no contact, stay away 100 yards from the residence and the place of work of the complainant. Do you assent to those conditions, sir?
Yes.
And you're
Okay.
hereby notified if you're charged with a crime during the period of your release, the bail in this matter may be revoked in accordance with Mass General Law, Chapter 276, Section 58. Thank you.
All right, what else are we gonna do?
Judge, if I may jump in right there, just for the record, we filed 2 arraignment-related motions, Your Honor.
Okay,
Obviously, we can push those to another day with 2 small exceptions of just an order to preserve notes of investigators and to preserve video, if I may, Your Honor. I don't believe there's an objection.
okay. Yeah, those are both ordered. So
Thank
he's the Commonwealth's ordered to preserve notes of investigators and to preserve video. What else can I do for you?
It's Judge Doolin.
For me or?
Why don't I start with you, Mr. Cosgrove? Go right ahead.
All right. So Your Honor, entered a discovery order the last time we were here. I made substantial progress on it. I can't say I fully complied with it, but I have about, let's see, somewhere in the neighborhood of 5,000 or 6,000 pages of discovery to provide Mr. Bradl today.
Oh, really?
And I had planned, Your Honor, to file that with a motion for a protective order, which I had served on Mr. Bradl a couple of days from the one I gave you.
Thank you.
And we have been going along with these, essentially tracking protective orders in the Karen Reed case, and in fact, much of the material is duplicative of discovery turned over in the Karen Reed case, and I've pretty much followed their form protective order. These have all been allowed with the agreement of the defendant and without prejudice.
Okay.
I understand that Mr. Bradl wishes to bring that practice to an end as of today. I'm in a somewhat
Judge is
I'm
laughing.
in a somewhat different position.
All right, let me hear from Mr. Bradl. Mr. Bradl,
Thank you, Your Honor.
give me your argument.
I appreciate it, Your Honor. Judge, the Karen Reed case is over with. It's moot. It's gone. Okay? And my filing, Judge, entitled Aidan Kearney's motion to release case documents from impoundment is what we're talking about here, Your Honor. So I asked the court last time, and we had so much business on the docket last time, I don't think we circled back on it. But I was asking to just release everything from impoundment, Your Honor. The fact that things are embarrassing or scandalous or cause negative light to be cast upon public officials, Your Honor, is not a reason to impound documents. It's actually a reason to release documents.
That's right.
And that's really all the Commonwealth has left on the existing stuff, is that, gee, this might make investigators look bad. This
Or
might
Marcy.
make special prosecutors, present company accepted, look bad.
Right.
This might, cause election shifts, and that's not a reason to impound things, Your Honor. And initially, we have sort of taken the candy from, from the Commonwealth, and when they say, just we'll give you the stuff, but just agree to this protective order. So we want the stuff, but at some point we have to get off of that train, Your Honor, you know. This is a case of immense public interest. This is a case of, you know, First Amendment issues, and I know we may disagree on that, but, you know, that's what our adversary system is for, and that's okay. And I think every case that eventually gets to the SJC or the Supreme Court starts with a trial judge maybe not agreeing with you, so that's okay. And, you know, that's what we have here. But in any event, Your Honor, I think we can agree that this case brings to the fore really important issues about what is witness intimidation, what is journalism, where does the First Amendment fit in? And, you know, these text messages about, you know, and I'm trying to not speak of them in open court, but we all know what they say, and we all know that there's a public interest in shining some sunlight on these things. So we're not asking to, you know, publish someone's address or someone's phone number. We're asking for the content of these communications that these folks have issued between and among each other. And the content of them per se has no persuasive power to make you want to impound them.
Let me ask Mr. Cosgrove, what interest at the moment does impoundment serve?
Your Honor.
Embarrassment.
I've just been handed 20 minutes ago a fairly extensive motion suggesting that I have all kinds of various burdens to justify impoundment and citing a lot of case law. I would like an opportunity to file a written response.
I'd give you that. Is a week enough?
I'd like a little more than that. Your Honor.
About 2 weeks.
All right.
There you go. I'll give you 2 weeks. I'll take it under advisement.
2 weeks for you, Cosgrove.
And if you want to file anything else, Mr. Bradl, Mr. Bederow, you absolutely have every opportunity.
Thank you very much, Your Honor. And
Now, Your Honor, with respect to the items that I was going to turn over today.
So I'll allow the motion. Mr. Bradl, I'm up here.
sorry, Your Honor.
It's all right.
Look over
I
here.
thought I had a minute.
That's fine. You got to talk to your client. You got to talk to Mr. Bederow. My point is this. If you want the stuff today, I'll allow it without prejudice.
Sure.
And then I'll see what you have to say and what Mr. Cosgrove.
We have to take the candy.
That's fine.
All right. Please note our objection, but thank you.
Yeah, no, that's fine. So I will allow Mr. Cosgrove's motion without prejudice, and I'll take any submissions that you have, and I'll give you a final answer probably in about 3 weeks.
Thank you very
Does
much.
that make sense? Okay.
And then, Judge, just to shift gears a little bit, there's some outstanding discovery that we've been talking about.
Yeah.
And I want to start off. I know that the court's time can be much better spent in discovery disputes. So we talked about the idea that we would go to the DA's office, and to the extent there's items that the government says they've given us that we can't open up or figure out.
Yeah.
You know, I think we're going to agree to go in person with our people and figure it out. So
yeah, sure. That's
the first thing I want to say. But then, in addition, Your Honor, there's this inventory that I filed. It's entitled Inventory of Outstanding Items in Connection with our Third Motion to Compel.
Okay.
There's about 10 things, Your Honor, and I think, unfortunately, that the government ought to go through and answer to us today about what the status of these things is. And we've been kind of going back and forth about these things for a long time. I looked back, Your Honor, and my first discovery request was February of 24.
Uh-huh.
And second and third, you know, were the months following. And you know, in fairness, counsel for the Commonwealth was not the prosecutor of record at the time, but you know, the rules are the rules, and we need this stuff, and it's gone on way too long. So these are the 10 things that I think are very important, and maybe 9.
Mr. Cosgrove, might you want to take that 2 weeks and respond to all of those?
Yeah, 2 weeks.
Could you give me an extra week, Your Honor?
An extra week.
Thank you.
All right. But it is, Mr. Bradl makes a very good point.
It's been a year and a half.
As we all know, I think that it's important that the discovery be turned over so that we can bring a timely trial to the case.
I don't disagree with Your Honor. Notwithstanding that Mr. Bradl has some complaints, and some of them may well be legitimate, there has been a substantial amount of discovery
Yeah.
turned over in this case.
Yeah.
Mhm.
If you're turning over 5,000 pages today, it's a lot of discovery.
We appreciate it, Your Honor.
Okay, great.
Thank you. And Attorney Bederow has a number of items as well, Judge.
Mr. Bederow.
Mr. Bederow. Oh, he loves Mark Bederow. Who
Just
doesn't
going
love?
back briefly to some of the issues about impoundment,
Yeah.
there are some items that are currently under impoundment, which we believe ought to be released from impoundment, specifically messages from Michael Proctor and a civilian witness. Those messages were cited in our motion to dismiss. As the court is no doubt aware, Michael Proctor is terminated from the state police. He has been a matter of public interest with his involvement in both the Karen Reed case, which led to Mr. Kearney's interest and ultimately, on some level, his indictment in this case. But also, those messages were impounded ostensibly for privacy interests, security interests, those sorts of things. Recently, Michael Proctor has been on a press tour on ABC News and NBC News, vigorously defending his investigative conduct. The messages that are at issue here, which are impounded, the public is entitled to see that. There is certainly a presumption of public access to those files. Michael Proctor has surrendered any privacy interest he has by addressing those issues, as has, the other civilian that we're talking about, who also recently appeared on national news with other members of her family, defending her and her family's conduct in this case. Those messages should be publicly available. If there's going to be information that's in the public realm, there's no reason why information that the prosecution wanted concealed from public view should be concealed any further. If the court likes, we can approach and show you the messages. I would suggest they are relatively straightforward.
Yeah.
And there's no reason for those to be impounded at this time.
Okay.
Let us have the message.
Anything you want to say to that, Mr. Cosgrove?
He's going to protect Jennifer
Not
McCabe.
going to give you another week.
Well, I would suggest it would make sense to take this up when we take up the other matters.
I think
No.
that makes sense too.
Yeah, I won't ask for another week. I won't ask for another day.
That's, why don't I do this?
Between Carrie
Why don't you all come up to
Carrie
the
Roberts
side?
didn't go
Let
on
me take a
TV.
look at what you mean.
He said this civilian witness is a she, and she went on TV recently also. It wasn't Carrie Roberts. It has to have been Jennifer McCabe or Nicole Albert, because they all did that friends and family interview, right? We want those messages. We want them today. Cosgrove has had discovery demands since February of 2024. And they're at sidebar right now. Cosgrove said that he just did he just turn over 5,000 to 6,000 pages of discovery, or he was just given 5,000 to 6,000 pages of discovery? He was arraigned on the new charges, the window intimidation charges, which happened after Aidan Kearney and the Galera and Meredith and Nan Gallagher left CF McCarthy's and walked over to the D&E Pizza window, and Aidan was intimidating the window. There was a camera inside that was videotaping him, and there was also a camera outside that had audio. And he's on video saying some things to the camera. And those witness intimidation charges are against Chris Albert, town selectman of the town of Canton, family member of Brian Albert. His brother is part of Canton PD, Kevin Albert, and his son Colin, as the Cosgrove likes to refer to him as Colin Albert, because apparently Colin was closing up the pizzeria when he learned that Aidan Kearney was next door at CF McCarthy's. It was very, very dangerous. And then Will the Glare was behind Aidan Kearney doing those like dinosaur arms in the window. And then he just pled guilty. I mean, not guilty. He just pleaded not guilty to both of those witness window intimidation charges. Will was not arrested, but he's a witness, as are the other two females that I just mentioned. But apparently there's been 5,000 to 6,000 new pages of evidence turned over. And Aidan's attorneys are fighting furiously to have all of this information unimpounded, because just because the DA might be embarrassed, just because other people might be embarrassed about these text messages and all of these.
You go back.
There's no reason to keep them impounded. The public needs to know. And D&E was closed at that time. That's right, KBD.
Mr. Bederow, the floor is yours. What else
Thank
you
you.
got?
Judge, one outstanding issue relates to the second of the three indictments that relates to Lindsay Gaetani. We moved and were granted a hearing to disqualify Mr. Mello from prosecuting that case because he is an essential witness in that matter. That issue was decided in September of 2024. A hearing was ordered in January of 2025. For reasons which the court is familiar with, that hearing has been put off. Nevertheless, we're looking to move this forward, and the issue is not resolved, and we're led to believe that Mr. Mello will not voluntarily withdraw. For whatever reason, we need to do this hearing. We believe that he's going to be a defense witness in this case. We're getting discovery between him and another civilian witness today, which I think is going to further that application and very likely make him even more a prosecution witness. And we just can't kick this can down the road for close to a year. So we would like to schedule a date for Mr. Mello to either appear, be examined under oath, explain the consequences, which the court, again, is probably familiar with. He was contacted by the complainants during the alleged crime repeatedly, 4 or 5 times over the course of that day. Instead of the police being called, he was an ear witness to these allegations. Respectfully, he needs to come in here, answer these questions so the court can issue a decision as to whether he's going to be allowed to continue or whether we can go through the process of subpoenaing him and any other items that might be of assistance to us with calling him as a witness.
Mr. Cosgrove.
Could I inquire if Mr. Mello is online?
I do not see him.
Margaret, we love you, Margaret.
Attorney Mello, last time he did use his name. There
is Mello on the Zoom?
Name on there this time.
Can I approach?
Of course. Come on up.
Come on up. They want Mello in. They want Mello to come in and testify on the record. He's been disqualified as the attorney for Lindsay Gaetani because, as I told you before, there was a text message thread between Lindsay Gaetani, Kate Peter, a.k.a. Mafia Massel, a.k.a. the not-so-confidential worst informant ever because she brags about it every day on Twitter. Mello and Tully, all of these messages are between and among them. And apparently, Mello was disqualified as being the attorney on the Lindsay Gaetani prosecution or the Aidan Kearney prosecution on behalf of the alleged victim, Lindsay Gaetani, all the way back in September of 2024. And they want Mello to come in and get on the stand and testify, and Tully too, I'm sure. It's getting good. Also, they should have to go on the stand. Mafia Massel, Kate Peter, Tully, Lindsay Gaetani. They were in cahoots. They were in collusion. And perhaps Mello is alive. Just perhaps, just maybe, they colluded to get Aidan Kearney's bail revoked because Lindsay Gaetani was in the bathroom while Aidan Kearney was outside the bathroom talking to Tully and Mello on her cell phone. They should have used Signal, says Brandia. Yes. Oh, yes. Oh, yes. Thank you, Steve. Quickly, back to the last discussion. Don't forget that Laura McLaughlin was the one who tried to assert consciousness of guilt when Karen sought out legal counsel. One of the most disgusting moments. Yes. Yes, she's had a lot of disgusting moments. Mama Texas, trash takes itself out. If you know, you know. Thank you. Tanya, have any of the Karen Reed jurors said which time they agreed she was guilty of OUI? 5 a.m. or 12:45 a.m.? Not that I'm aware of. I don't think it matters. Because the OUI charge was not contingent upon a time. Journalism is not a crime. Free the turtle, says Just Irish. They're at sidebar right now. Thank you, Michelle. Appreciate you.
Mr. Bederow, you said you had one more thing.
Yes, Judge. Just as it relates to discovery, we have made a series of discovery demands from the prosecution ranging from October of 2024. As of this date, not including whatever was filed today, we have made 4 very thorough, detailed discovery demands sourced regarding contacts between a civilian named Catherine Peter and the state police and the district attorney's office regarding her very unique relationship in all matters involving Mr. Kearney. Those demands, which again are in the files, Mr. Cosgrove has them outlined in detail, her frequent contacts with the state police, with people that are prosecutors, statements that she has made under oath in court proceedings stating that she helps authorities get Mr. Kearney, voice recordings that she has left Mr. Kearney indicating that she provides information to them. So we have asked for any discovery related to Ms. Peter going on about a year. Now, today, for the first time, we are admittedly getting something that relates to her communications with Mr. Mello. I'll only note that all materials that relate to Ms. Peter and the prosecution were ordered by the court in early May to have been provided within 20 days. That didn't happen. We got stuff today. That's fine. But the real issue here is that in light of the change in Rule 14 from last March, the game is very different than it might have been before in terms of what the prosecution is obligated to do and what I don't believe they've done in this case, which is go to every member of the prosecution team, which is everyone in the district attorney's office, any of the state police who are involved in these matters, which includes Michael Proctor at the time, Yuriy Bukhenik, Lieutenant Tully, Fanning, there's a whole list of them. The Karen Reed prosecutors who are also covered, who got a little bit involved, as the court is aware, in Mr. Kearney's case and may or may not have had a relationship with her too. She has made statements allegedly indicating some involvement in that case. The rule requires the prosecution, whether they credit the information or not, to contact each individual that is on the prosecution team and make an inquiry and find out whether there is any material and disclose it. We don't think that that has happened. We respectfully submit that is something that Mr. Cosgrove has to do. In particular, I would draw the court's attention to testimony that was given by a member of the state police in February of 2024, which led to a wiretapping charge against Mr. Kearney, in which Fanning of the state police stated under oath that they received a recording, a 30-second recording from Catherine Peter, that it was given to Lieutenant Tully and then given to Fanning, and we have no evidence of that. We don't have a copy of the recording. We were given the wrong recording in that regard. We have no police reports. We have no communications. We have nothing. If they don't exist, they don't exist, but they're obligated to look for it, make the inquiry, and report back and say whether any of this exists or not. And the last thing I'll note on that point, under the new rule, it doesn't matter whether the prosecutor credits any of this, thinks it's nonsense, thinks it might be real. They're obligated to do it, and we simply ask respectfully that the court instruct the prosecution to do that and disclose whatever evidence ought to be disclosed, or make a statement on the record that there is nothing to disclose. And if that's the case, then we'll all live and die with the consequences of that statement.
Okay, Mr. Cosgrove.
It's largely been done.
Is that part of the 5,000 pages that you're turning over?
It is. Among the things turned over is the email from Catherine Peter to Brian Tully providing that 30-second clip.
Gotcha.
The email,
Okay.
but where's the clip?
That's fine. So that seems to solve that. You said that you had some things you wanted to bring up. Go right ahead.
Yes. So this will be an opportunity, Your Honor, for myself and Mr. Bederow to do an absolute 180 on our positions on disclosure of impounded documents. Your Honor will recall that the last time we were here, attached to a discovery motion was an affidavit.
Oh, yeah.
And at that time, it was initially filed provisionally without hearing from the Commonwealth, was impounded upon, I believe, not the affiant's representation, but I think Mr. Bradl's representation that the affiant was in fear that there would be some sort of retaliation by the Commonwealth. I think Your Honor will recall the fairly outrageous, if I can put it that way, representations that were made by the affiant. I believe now, as I moved at the time, that affidavit should either be stricken or that the impoundment order should be lifted. I don't believe an affiant should be allowed to
That's the neighbor of Kate Peters that
accuse
said
an
that.
assistant DA of jury tampering and the district attorney of having secret meetings with witnesses and all these other things, and then hide behind an impoundment order.
Okay. Let me hear from the other side. Mr.
About the
Bederow.
couch.
Yes, a couple things that I think ought to be corrected. The affiant is not alleging what happened. The affiant is alleging under oath that she was told by another individual who we were discussing earlier what happened. That's the first point. The second point is that document was attached as an exhibit to a discovery demand. Discovery demand number 4, alleging more reason to believe that there is an obligation for the prosecution to look into possible discovery that is in their possession, custody, or control. If that affidavit were to be stricken, that means literally nothing. They are still obligated to do whatever it is they had to do. And at the time that that motion was discovered until 20 minutes ago, absolutely nothing has been turned over regarding this person who brags about working for the authority. So I don't know the relevance of doing anything one way or the other with respect to the affidavit. Now, that person may very well have a privacy interest because the day after that affidavit was filed, her apartment was essentially covered in personal information about herself that could have only come from someone with access to law enforcement. And almost certainly that individual was subjected to charges of witness tampering, which I believe were actually under investigation and may still very well be. I can't go farther than that. I don't know. Somebody, whoever did this, wrote snitch on her door. So I would suggest in this situation, impoundment of her name is more than appropriate.
Okay.
I'd just make 2 points in response. One, I don't think it's entirely true that the affiant was simply relying on recounting hearsay.
Oh, really?
If she was, that would say something about the credibility of the affidavit as well. But I seem to recall, Your Honor, that at least one point the affiant represented that she was present when Ms. Peter, I believe it was having a phone conversation with Hank Brennan, and that she, the affiant, recognized Hank Brennan's voice because she was familiar with it. So I don't think it was simply a matter of hearsay. The second thing I'd say
We're all
is that
familiar
the
with Hank
identity of
Brennan's
this
voice.
person is all over the internet, and was all over the internet at the time it was before you the other day.
What?
I don't know what the interest is, given those circumstances, in concealing it in the
Impoundment means
in the
it's
court
sealed.
papers.
It's sealed from the public.
Judge, I'm sorry, one.
And I'm sorry.
I'm sorry, go ahead.
Could I just add one thing?
Yeah, go
Go right ahead. Doolin's the best. We love Judge Doolin. They're talking about the neighbor of Kate Peter, right? Kate Peter's neighbor said that Kate Peter told her
Apparently these
that Jen McCabe bought her a couch.
things
among
that
others.
were affixed to her door in her apartment building, which is the same apartment building that Ms. Peters lives in.
Colon.
And I think the implication was made at the time, first of all, that event was publicized by Mr. Kearney on the internet with photographs of the door in question. And I guess I would just question, Your Honor, the source of those documents, let's put it that way.
Okay.
Just very quickly, Your Honor, in terms of this individual's name being on the internet, there are two reasons for that. The first is because Ms. Peter identified her publicly and led to this kind of harassment. The other reason, and this was no question a mistake, but Mr. Cosgrove mentioned her name accidentally, and no question, no malintent, but her name was stated in open court, and as you can see, people watch in court, online, and whatnot. So the fact that her name had been put out accidentally through no fault, with no malintent, is not a reason, I think, to just open up the affidavit to her name.
Okay. Thank you all.
Yeah, Cosgrove did it.
So we have a date for, what was that, August? What was the date, Margaret?
August 13th for
August
discovery
13th.
compliance.
And then we'll pick a date for the other issue. Am I correct, Mr. Cosgrove?
Yeah.
Towards the end of the month?
Now, or do you want to pick it on?
Why don't we pick it on the 13th? I think that makes sense.
All right, I may have some, I'm sorry, I should be standing.
That's okay.
I may have some information about
That's fine.
the health status at that time.
All right. We'll see you all on August 13th.
Thank you.
Okay, thank you all.
One more, Your Honor.
Go ahead.
Oh, sorry.
One more.
I believe we have an agreement. Mr. Bradl has responded relative to the source code for accessing the search of the devices.
Yep.
And he's indicated there was the same source code previously provided Lieutenant Tully, and that he would supply it again if necessary. And I've indicated to him that that's appropriate, and I think he should supply it today.
So,
And I
Mr.
don't think
Bradl?
there's a disagreement with that.
All right. You don't disagree with that, do you?
Sure.
Yeah, all right, good. I'll see you August 13th.
Thank you.
All right, take care. Bye.
2 p.m.
2 p.m.
Thank you.
2 p.m. to see if they've complied with, discovery. Nothing ever gets done. There's no cameras. They don't want anybody to know about this. Just make sure they're totally finished.
We have any lobbies we could go?
Yeah, we're gonna take that. We'll take it across the street.
Hot mic, Tim Bradl, hot mic. We can hear you.
Get out of it. Just get out of
Hot
I'm not
mic.
aware that, I'll check on that. I know I saw something.
Mark
where she
Bederow, hot
said
mic.
In a text message. to
Kelly,
this
you're in the courtroom.
lady,
Tell Mark we can hear him
this
on a hot
message,
mic.
Yeah, she said.
Hello. Cosgrove turned over 5,000 to 6,000 pages of discovery today. All that stuff. All the text messages maybe that they were looking for between Kate Peter and Tully and Mello and Lindsay Gattani. I'm going to go over the Bederow letters with you now because some of you might be like, what the hell is going on here? Turtleboy's phone has never been returned to him.
Court number 18, almost.
And we just learned in the Brian Walsh case, even though he's been accused of taking the wife of his life, Anna, and dismembering her and putting her body parts all over town, his devices were given back to him within 18 hours. Yep. Yes, they were. You can't make that up. No, you can't. So for those of you who may not be familiar with the Bederow letters, let's go back to the Bederow letters so you know what they're fighting about now. But just to recap what we heard today, Bederow and Bradl both got to speak, and that was exciting for us. Bederow and Bradl are like, unimpound everything. We want everything unimpounded. There's no reason to keep all of these documents impounded, which is a fancy way of saying sealed. In Massachusetts, we call it, in New York, we would call it sealed. Massachusetts, they call it impounded. They're saying the Karen Reed case is over. You can't keep things impounded just because it's going to embarrass maybe people like Morrissey, Proctor, because remember, they got access to all of Morrissey's private emails because Morrissey emailed some people on his private burner email account, not just some people, the judges in Stoughton Court, and said one of his constituents has grave concerns. I don't know if he said grave concerns. I'm just going to summarize. about the Stoughton District Court because Chris Albert was not granted a restraining order against Turtleboy, and attached to his email a text message from Jen McCabe directly to Marcy saying, Chris didn't get it. I know it's late, but I am outraged, whatever, whatever, whatever. Michael Marcy emailed all of the district court judges in Stoughton from his private email account. And guess what happens when you do that? Well, it makes all of your emails from that account subject to FOIA requests. And so there's been 5,000 to 6,000 pages turned over today. And they're like, well, none of this stuff should be impounded anymore, Judge, because the Karen Reed case is over. It's moot. And it's not enough of a reason that, certain public officials might be embarrassed by these documents that we should keep them impounded because, the public has a right to know. He said, Michael Proctor's been on a press tour. Michael Proctor's been out on a press tour. In addition to one of the civilian witnesses that he was texting with, she's also been on a press tour with her family. We're surmising that he was talking about Jennifer McCabe because, apparently there might be some text messages out there between Michael Proctor and Jennifer McCabe. And we want them unimpounded because we have a right to know. There's also some recording that Kate Peter, aka Mafia Mansell, aka Not So Confidential Informant, sent to Tully, and he sent it to Fanning, and it's a 30-second recording, and they don't have it yet. And Cosgrove said, well, I turned over an email from Kate Peter to Tully as part of the 5,000 pages, and so, but that doesn't mean that the recording was attached to it. And then Cosgrove, had to clap back and said, well, what I want to know is, I also think that you should unimpound the name of the person who wrote that affidavit. It happens to be a neighbor of Kate Peter, who she signed an affidavit as, Bradl and Bederow were fighting for all of this discovery. She signed an affidavit that they attached to a motion that said that that Kate Peter told this woman that Jennifer McCabe bought her a couch, a sectional, and that she had lunch with Brennan and all of these other things that we could pull up and talk about. But it was a woman who lives in Kate Peter's building that apparently used to be friends with Kate Peter, and Kate Peter used to tell a lot of stuff too. That is now in an actual affidavit. But here's something that has just been reported on Twitter by Howie Carr. Please do not say I reported this. This is Howie Carr reporting. Another one bites the dust in Norfolk County. Trooper David DiCicco on Proctor's infamous text message chain is now reassigned to the Holden Barracks per MSP statement. Take cover, Turtleboy. DiCicco made $181,000 last year. Remember DiCicco? He's the one who said, rookie move in the text message thread with Proctor when Proctor said, Yuriy and I tried to visit Irene Scorti-Bello, that whack job ME, and we tried to get her to change her manner of death and John O'Keefe's death certificate from undetermined to homicide, but she just wouldn't do it. And David DiCicco said, rookie move. You should have had me and Jeff do it. We're talking about Jeff Kakowski. What else is DiCicco in? Oh, that's right. He's involved in the Walsh case too, isn't he? Yep, he is. We're all in on the same joke now, aren't we? He's telling them everything. He's telling them everything. Something is happening. Something big. Something big's happening. Let's go back because many of you may not know about the Bederow letters, and it's going to set forth a lot more of what they're looking for in here. And Bederow, he wrote some amazing letters. We read them together. The first of which goes all the way back to September 12th, and it's going to set forth a little bit, perhaps for some of you who are not as familiar. We'll skim through it because I have a lot of, there's the show notes of this video is the playlist on Aidan Kearney, and it's got all the videos that we've done. We've followed all the hearings and all the filings, the motion to dismiss. There are only 10 felony charges remaining, I say, because he had 16 originally, but he's still looking, Aidan Kearney, at about over 100 years in jail because of the witness intimidation law that is selectively prosecuted in Norfolk County, Massachusetts, in my opinion, and also in Mark Bederow's opinion. So let's take a look at the first letter that Mark Bederow wrote that sent us off into this world of discovery. And apparently, according to documents, and discovery orders. Cosgrove, the special prosecutor who took over from Mello, who may or may not be missing or injured. There's been many discovery orders. And as of the last discovery order in May of this year, they had 20 days to turn over all of the discovery, and they still didn't do it, although they turned over 5,000 to 6,000 pages of it today. But since October of 2024, Mark Bederow has been writing these letters asking for the discovery and setting forth all of the reasons they're entitled to it. So let's look at the first Bederow letter, which goes back to September 12th. Also, Aidan Kearney's defense fund link is pinned in the chat for you to contribute, because he's protecting the First Amendment in Massachusetts. The reason, perhaps, that Karen Reed's case got so much coverage and attention is because of all the investigative reporting that he did on this case, on Karen Reed's case, since April of 2023. And he did more of an investigation into the murder of John O'Keefe than the Massachusetts State Police and Canton Police did. So go figure. His defense funds is now up to $195,020. I'm going to ask that rather than super chat me today, you make a donation to his defense fund. I've pinned that link in the chat for you, because your constitutional rights are at issue in Massachusetts. And Turtleboy, aka Aidan Kearney, served 60 days in prison or jail. Sorry, it was jail. 60 days in jail in the Norfolk County Pokey. Coincidentally, Brian Walsh was there too. When he was maybe set up by not so confidential informant Kate Peter and Lindsay Gattani and Tully and Mello. Okay. Here's the first letter of Mark Bederow, September 12th, 2024. And this is to Robert Cosgrove and Ken Mello, because nobody really knows who's in charge there. Who's in charge? I don't know. It's kind of like, is anybody watching Gilded Age last night? It's like the servants didn't know who was in charge and who to take orders from. Nobody knows where Ken Mello is. Robert Cosgrove has taken over. He's a retired judge, coincidentally, or maybe not so. Coincidentally, from Norfolk County, Robert Cosgrove is a retired judge. Calls Colin Albert Colin. And nobody writes a letter like my friend Mark Bederow. And why is this one not marked up? Oh, it is. It actually is. Okay. And then, of course, the letter is addressed to Messrs. Cosgrove and Mello. How many people still use that, Messrs? This letter serves as a specific request under Brady v. Maryland and Graham and Rule 14 of the Massachusetts Rules of Criminal Procedure for the prompt disclosure of. This is what they were looking for, and I don't think they've gotten it yet. A, an unaltered and complete extraction report from the cellular phone Lindsay Gattani provided to Massachusetts State Police Detective Lieutenant Brian Tully, Trooper Nicholas Garino, on or about January 10th of 2024. B, any information in the possession, custody, or control of the Norfolk County DA's office and or the Special Assistant District Attorneys assigned to Aidan Kearney's matters that tends to impair the credibility of any possible witnesses against Mr. Kearney, including but not limited to Juliana Nagel, Matthew McCabe, Jennifer McCabe, Chris Albert, Colin Albert, Elizabeth Proctor, Brian Albert, Ms. Gattani, MSP Trooper Michael Proctor, Sergeant Yuriy Bukhenik, DL Tully, and Trooper Garino, including but not limited to evidence related to any investigations into any witness's conduct by the U.S. Attorney's Office for the District of Massachusetts, the FBI, any other federal agency, the Commonwealth, the Massachusetts Attorney General, the Massachusetts Peace Officers Standards and Training Commission, or any other agency or governmental body. C, all promises, rewards, or inducements made to any possible witnesses against Mr. Kearney. And D, because here's what came out recently, is that perhaps Kate Peter, aka Mafia Masshole, is being paid $1,500 a month by the Norfolk County DAs. All right, so who's got Bederow talking to the press right now? Hang on. Is it live? And who's got it? Tell me who's got it. Oh, Tom CPU. All right, I'll play it, but you guys got to go follow Tom CPU and give him a big like on this, okay? Let's shift there for a moment. And we can also rewind it, so don't worry, don't freak out. Oops. Shout out to Tom for doing the Lord's work. The signal is not always great there because all of the news trucks are there and they suck up the signal. Tom CPU is out there doing the Lord's work. So let's give him a shout out and a like and a love.
If I could do a turn around, you know, you gotta maybe ask them.
It's Bradl. Shout out to the boots on the ground. Here they come.
You want any pictures? Let me know. You're immediate.
Oh.
Could you see
No, I suppose just go over there. Ask them.
Okay, it's Bradl.
So, I know they had like how many documents?
Yeah, it looks interesting. 5,000 pages. We'll have it worked out for us, and I think it'll probably move the needle pretty well.
5,000 pages.
Looking forward to looking at it.
I may have missed it. So,
Hey,
can you
Jess.
hi, Attorney. How are you?
Good.
Can you talk a little bit about removing Attorney Mello from this case? Have you spoken to him?
That is Jess Machado. We were just following her on Twitter. Jess Machado Show on Twitter.
Is it something he's not willing to do? He stated that he's not going to remove himself. How's that going?
We haven't spoken with him. I think you know, it's been papered throughout the case. We filed all sorts of motions. We just want to be heard on it. There's all sorts of issues with it, and you know, we're just going to fall back on the papers that we filed on it. We're just at this point, we're just trying to get a hearing so we can, you know, make our arguments that we've laid out.
Have you ever seen a case where you've had an attorney that started off, that left the case and is now a key witness in the case? Obviously, based on communications with Lindsay and Kate, this is a very interesting situation.
It's unprecedented for me. I've never had a case where a prosecutor got involved with the witnesses and then became somebody that was going to have to be potentially testifying as a potential impeachment witness or a fact witness, getting calls at 3 o'clock in the morning,
Right.
you know, while my client is in the,
Ken Mello's
in the house.
getting calls at 3 a.m. and now he's a fact witness. Is there any? I don't see any mainstream media there.
It is unprecedented.
Right. What do you make of the judge's kind of jovial, laid-back vibe today? He seemed in a great mood. He laughed a lot. Can we interpret that as him not taking this seriously? How should we interpret this?
No. Judge Doolin is the best. I mean, you don't get any better than him. He's been around. He's walked the walk. He was in the DA's office. He's been a defense lawyer forever. He's terrific. I mean, he's so.
Mainstream media is not even there. Here comes Aidan. Shout out to Tom CPU.
Yeah.
Hey, I noticed you took part in the bench hearing. Conferences. How'd that go for you?
Karen can do it. Why can't I?
Yeah. Was it worthwhile?
Yeah. Find out interesting stuff that you don't know is happening.
You can't talk about them.
Yeah, you can't talk about them, but you know, apparently you're out there, so why not?
So how did they win? Are you comfortable with everything?
Oh yeah, it went great. I mean, we've got a lot of stuff out there. I mean, the big thing is there's all this discovery that's compounded, and we've had it for months and months and months, and we can't talk about it. There's no reason not to talk about it. It's in the public interest. It's outrageous, and there's just this cloud of secrecy that exists in Norfolk County where they think they can operate in the dark and do whatever they want, and no one else gets to know except them. And that's just not how the United States of America works. It's not how freedom works. So I think it was a good day. I think Judge Doolin seemed pretty receptive to it. So yeah.
He told me to tell you guys not to.
Jess mentioned that. She said it's kind of jovial at times, that those sidebars. In fact, I was glad to see you were up there because maybe I thought it would be less yucking it up with the good old boys. But I know how it works. You got the judge, he knows the attorneys, they're together on a lot of different stuff. But with you sitting there kind of monitoring it, do you feel like he took it as seriously as he should?
Oh yeah, I mean, I can't just talk about what was discussed up there, but it was interesting.
Aidan, how do you feel about Attorney Mello possibly becoming a witness in this case? He was originally the prosecutor, and now we're looking to have him moved over to be a witness. How do you feel about that? And how do you feel about the integrity of this initial investigation in case, knowing that he may now be a critical part of testimony in regards to these witnesses?
Well, it's undeniable that he is a witness. Unprofessionally, in my opinion, he instead of alert, sending these people to the police. He acted as their own personal police, and he became a witness. And he's definitely a witness. So.
There's some support.
I feel like the court was looking for his name in terms of being attorney of record still. I saw the court looking for. I mean, is Mello an attorney of record in this case still?
Yes. Yeah, he's still on all the emails.
That's ridiculous.
Yeah.
I mean, why is that?
You'd have to ask him.
Inertia.
Yeah, I mean,
He's still cutting a check out of it.
you'd have to ask him.
Mr. Bradl, how was the day for you? Day was fine. Just as far as the Mello situation, there are issues, obviously, but the bottom line is never in 26 years have I ever seen a situation where an alleged victim of a crime calls a prosecutor in the middle of the night or while the crime is happening instead of 911 or the police. Once that happened, he made himself a witness, and that's just the way it is, and that has to be resolved. He's entitled to a fair trial. He's entitled to a trial without conflicts, and we're entitled to call someone who is a fact witness. And the fact that he happens to be the prosecutor, as regrettable as that is not a basis to get a pass. So we fully expect that we will have him removed from this case and potentially subpoena him and have him testify. And I think it will be favorable. We'll see.
How confident are you that you are going to receive all of the discovery that you've asked for in 3 weeks?
We'll have to wait and see. I take Mr. Cosgrove at his word. He did jump on this late. Other people were involved beforehand, but we're entitled to what we're entitled to, and we're going to get it, and we'll continue to complain until we do. And again, that's the centerpiece of a fair trial. We're entitled to material. We want it. And if you don't give it to us, then that's at your own peril.
Can you elaborate a little bit more on your statements regarding Michael Proctor? You said that he's out doing a press tour, that the expectation of privacy has kind of all gone out the window at this point. Can you talk a little bit more about
Michael Proctor is a disgraced, corrupt, former state trooper who was terminated.
Tell us how you really feel, Mark. Mark never holds back. Mark never, ever holds back the way he feels about Proctor. And this is Tom CPU's channel right there, at Tom CPU. I will put it below so you can go give him a like and a follow.
Terminated for his conduct in the case that Mr. Kearney covered, and that same agency is the one who arrested him. There are communications which are impounded, I'm not going to get into them, that I think would shed a lot of light onto that. Now, as far as them being impounded for witness privacy issues, this man went on a press tour a few weeks ago and emphatically denied doing anything. We don't agree with that. But if you're going to put out piecemeal coverage publicly, trials are supposed to be fair, open, public access. The public ought to see exactly what he was saying and who he was saying it to before he was arrested and why that was. It's just public access and part of a fair trial. That's all.
So who is the Commonwealth protecting at this point?
I'm not going to speculate on who they're protecting. They seek impoundment of virtually everything, which is the antithesis, again, of what a fair trial is. There should be
Wait, stop. I just want to come back to your screen if you're not on scaffolding or driving your 18-wheeler down a highway, and you can do so safely. Just come to your screen for a moment to check out the sartorial splendor of three of our favorite gentlemen in Norfolk County, Tim Bradl, Aidan Kearney, and Mark Bederow. Bradl and Bederow in the tan suits, ties on point. Aidan Kearney in the navy suit with the pink tie, and their ties are all on point today. They all look great, and my freeze game is on point once again.
Presumption of openness. There should be light, not darkness. But for whatever reason in this county, in their high profile cases, they seem to have a presumption of darkness. We don't accept that.
All right. Thank you, guys.
Color coordinated and fed.
Thank you. And you want to say anything to everybody else?
Bederow, love you guys.
Be there on the next meeting.
Oh, nice to meet you. Yeah, of course.
Yeah, and you, can you take,
And now they do the photo ops. Wow, what a great Monday. What a great Monday. So, yeah, we had over 19,000 in here all day. Well, for this hearing. So hit that like button because it really helps the girl out. It helps with the algorithm. There's a whole algorithm thing. Look at Australia is here rooting for the turtle. The virtual juror says Mercury, Saturn, and Neptune are in retrograde. That explains it. Thank you, Susan, for gifting another 5 memberships. I think you've already gifted at least 20 between this morning and this afternoon stream. Thank you so very much. Donna, we spoke about that earlier. Daniel Wolf's Dimples is here. Australia's, we're rooting for the turtle. And Krista says, just reported Kelly Reed is there with Meredith. Yes, I knew that Kelly was going to be there. She's there to support. I didn't see her in the crowd here, but we didn't get video of the courtroom yet. So, you know, we got the Zoom feed, but it was still good. We heard what was going on, right? Casey Cat says sunlight is the best disinfectant. Yep. Karen Reed said that. Mrs. Smiley, thanks for becoming a member. It's Jen McCabe, and she's in court today. She was in court. Was Jen McCabe in court? Do we have any confirmation of that? Did anybody tweet that with credibility? Or do we have photo evidence that Jennifer McCabe was in court today? I can't believe that she would show up. Well, maybe she did because she knows that her text messages with Proctor are out there and they were going to be brought up. Could that be true? I don't know. She is also one of the alleged victims in the witness intimidation charges. Read case is over, so no bail revocation, says Virginia. Thanks for hanging out with me for 15 months. You're awesome. Mute vote 9. As the witnesses have put their mental health at issue, does Turtleboy get to hire experts to assess the victims about their mental states? Feigning? No, I don't think so. I don't think they don't open themselves up to mental fitness examinations. They would in a civil case, but not in a criminal case. Everyone go give Tom CPU a like on that video and sub up. He's out there doing the Lord's work all the time in front of the courthouse. Lindsay, window intimidation via wiretapping. That is correct. MSP has posted that Yuri's job at Norfolk is now hiring. Yes, I said that earlier. If you'd like to apply for the job that Yuriy has been rehomed from, you too can be a sergeant at the Norfolk County DA's office with the MSP. So good for you. I just wanted to set the record straight. Keeping our public lands open said the camera outside, referring to D&E Pizza, Chris Albert's Pizza Shop, is visible and everyone should assume they are recording video and audio. First Amendment, anyone has the right to video and audio record in public. I just have to point out that you are incorrect, not in Massachusetts. Massachusetts is a 2-party consent state and you cannot record anyone's audio without their consent. That was pointed out in one of the Bederow letters when Mark Bederow, after the window intimidation charges, wrote a letter to Mike Morrissey and said, or Helena Rafferty, who at the time was the Canton police chief. Everyone keeps being rehomed and retiring and leaving and quitting and leaving skid marks that it's hard to remember who's even there. But Helena Rafferty, who was the chief of police in the town of Canton, well, she was the chief of police, and the boss of the chief of the police is the Canton Select Board. Chris Albert sits on the Canton Select Board, so he's the boss of Helena Rafferty. So Mark Bederow wrote a letter to Helena and said, Helena, hello, honey, you need to persecute or prosecute Chris Albert for illegal wiretapping because, as you know, Massachusetts is a 2-party consent state and you're not allowed to record people's audio without their consent. And so his video outside of his pizza shop has audio. And I said, how many people sit outside that bench at D&E and tell each other their secrets at night after coming out of CF McCarthy's and maybe having a couple? And so how many people has he been surveilling forever? And then Helena Rafferty retired or left or jumped ship or something. And he's not been prosecuted for that. No, he hasn't. Because that's how they got Aidan Kearney on alleged illegal wiretapping charges, was because he recorded something, a conversation with Lindsay Gattani, even though he really said, I'm recording you, right? Aren't those the wiretapping charges we're talking about? So you can't, here's the thing. You can't selectively prosecute the laws. You just can't. You're not supposed to. They do. They do it in Massachusetts. You can't say we're gonna get Aidan Kearney for illegal wiretapping because he recorded a conversation with Lindsay Gattani, but we're not going to go after Chris Albert, who happens to sit on the town select board, because he's recording every single person who sits on the bench outside his D&E Pizza Shop. And then you can't persecute Aidan Kearney for witness intimidation when you don't prosecute the people who are actually going after the jurors in the Karen Reed trial. It's wild. T-Bone says, bang, pow, wham. Thanks for your super chat. Max Bang says, Jen went on a press tour but didn't run into her sister's home where a man was found dead on her lawn. If you know, you know. Right. Clueless. Yuriy has been placed on a desk job. Yes, we covered that earlier. If you didn't hear it, we covered it this morning on the Brian Walsh, and then we covered it earlier today. We read the article, and you can rewind to the beginning of the stream. And we also just learned that DiCicco has also been rehomed, as was Fanning and all of them. Thank you for the love of the traveling trooper. Be careful if you're a witness. What am I a witness to? I don't know. Tony says, is I Want Candy on the playlist? Well, the playlist was for the Karen retrial, and I don't know if I Want Candy was on it. If not, can we add it, please? Thank you, Melanie, for shining this light. Patriotic says, this is why the Bederow letters were crucial. Yes. Al Dente says, Mello is removed. Bet you Brennan is trying to prosecute. Bet you Brennan is trying to prosecute. A lot of people think that. Yeah, Mello is a witness. They want him on the stand. They want him on the stand. Yeah, Cosgrove, you had Bederow letters for how long? How long? Bederow not only bringing receipts, he brought the entire internet. Oh, yes, oh, yes, oh, yes, he did. Praise be, says Pinky. Marley, Free Turtleboy, if you have time, can you give a quick rundown of this after? I know some of this, maybe others do too, watching from, I think that says the UK or England. Thanks. Yeah, we were going to go through a Bederow letter or two. Film Freak, thank you for the in-depth research and analysis on these important cases. Ably assisted by a very capable chat community. Love you all. Thank you so very much for noticing. We try here. We try. We ain't got no quit. We ain't got no quit. Bederow is telling them everything, said for the love of the traveling trooper. Persephone's pomegranate says, it sickens me he's not getting widespread coverage. This affects all reporters' jobs, not to mention the American Constitution. Phony baloney canoni. Melanie, don't take your foot off the gas. You're shining much needed light on Massachusetts corruption, and we are witnessing the results of your hard work. Thank you. Thank you. I appreciate that. Aidan Kearney too. And all they want to do is throw him in jail for 100 years plus. Even if you're lurking, hit the like button, says Thunder Horse. The Goodmans are here. The gifted 5 memberships. Thank you, Goodmans. Thank you, Just Irish, for thanking me and for hanging around with me for 10 months. Mo S says, thanks, Melanie. Great to hear from Mr. Bederow today, says ShamWow, wasn't it? Florence Not Nightingale says, thanks for continuing to cover this saga. Freedom of speech with an FREAD. Side note, I can't wait for you to get back on Lisk, new documentary. Oh, I didn't see the new doc. I'm not really a fan of those documentaries. Who did the documentary on Huerman? Because, they're not always accurate. Did you think it was accurate? Lily Rose says, it's incredible the mainstream media isn't there while Aidan's getting charged for journalism. That protects them too. Shameful, just shameful. Yeah. Back to the Bederow letter, because I don't like to leave anything unfinished. So this is the September 12th letter. They also wanted all the grand jury minutes for the grand jury, and that was convened. In December 2023 and February 2024, for which an indictment against him and Karen Read was unsuccessfully sought in March of 2024. It has been said by Saul Walkler, who was the Chief Justice of the state of New York, he had his own problems, but he famously said, a good prosecutor can get a grand jury to indict a ham sandwich. Well, the grand jury did not indict the ham sandwich of Aidan Kearney and Karen Read all the way back in March of 2024, but they tried. Oh, did they try? They tried because they wanted Karen's bail revoked. They wanted her in jail, and they also wanted Aidan in jail. Aidan did do 60 days. Oh, it's on Peacock, the Lisk thing? Okay, good. And then Bederow also called for the recusal of Mr. Mello. If he doesn't recuse himself, he said, we will seek his immediate disqualification at the September 26th of 2024 appearance because he's an essential defense trial witness. Well, he did not apparently voluntarily recuse himself, and he actually was disqualified, as Mark Bederow told us during that hearing, because he's a witness. They're looking, okay, so they were looking for the extraction report from Lindsay Gattani's cell phone. And you can It says that in April of 2024, Mello provided the defense with an extraction of her cell phone. And then in July, after the defense expressed concerns about the completeness of the report, Mr. Cosgrove assured the court and the defense that whatever the communications are, they're all turned over. However, well, they caught him in a lie. Notwithstanding Ms. Gattani's acknowledgement that she communicated via text message with D.L. Tully and Mr. Mello and then deleted the messages, the extraction report does not contain any text messages between and among Ms. Gattani, Tully, and Mello, except for one that Gattani sent to Tully at 10:48 p.m. on December 23rd of 2023. This is when she's in the bathroom and Turtleboy's outside the bathroom. And here's the message that she sent to Tully. Ken said to call you, but I can't now. Mr. Kearney is knocking on the bathroom door. I guess it said Aidan because that's in parens. I have to go back out. Please don't text or call and tell Ken not to because he wants to see my phone. I'm deleting our calls and texts right now. Don't respond until you hear from me. Yep. Nor does the extraction report provided to the defense include a media file that Leah Genduso and sent Ms. Gattani during a text message exchange a few weeks prior to Mr. Kearney's arrest. So it looks like some of this, some of this stuff may have been doctored or proctored before it was turned over to Aidan Kearney's defense team. Are you shocked? He goes on to say that on December 9th of 2023, Ms. Gattani reached out to Ms. Genduso specifically because she knew Ms. Genduso despised Mr. Kearney. Around the same time, Ms. Gattani began communicating regularly with Catherine Peter, another individual she knew was an outspoken enemy of Mr. Kearney. On the evening of December 11th, 2023, 2 weeks before Mr. Kearney's arrest for allegedly intimidating, quote, witness Gattani, Ms. Genduso and Ms. Gattani engaged in the following text exchange. Ms. Genduso, I think by going to Mello and becoming a part of this on a DL will inevitably help be another stepping stool into getting Mr. Kearney put away for a substantial period of time. Aidan's going to have a big reality check very soon and will be in jail before the summer. I really stand fast to that. And then Ms. Genduso said, holy crap, I just thought of something. OMG, OMG, OMG. And she sent a media file to Ms. Gattani. To which she replied, Ms. Gattani, I'm going to call Mello tomorrow. Ms. Gattani, listening now. OMG, did not even think of that. Yep, it took me all day for the light to come on. Haha, I can't believe me and Kate didn't either because we were literally talking about the bogus witness intimidation charges he filed on her and how he is considered a witness. OMG, the joy it would give me to play him at his own game. 100%. I still think he'll be stupid or cocky enough to post stuff about me, even if he knows I'm a witness, but at least I know he will be charged if he does. Mello is our only hope right now. Half of the conversation is missing. Exactly. And if you're interested in this, there's a playlist linked below with all of the Bederow letters. I think we did each one in a separate stream because there were so many of them. All of these things just inexplicably disappeared. They just disappeared. And then there's more evidence of a Lindsay Gattani fake Twitter account. And this just goes on and on and on to the point where you just can't even make any of this stuff up. In fact, Tully or Mello, one of them served Lindsay Gattani with a fake grand jury subpoena in order to make her a witness under the terms of the witness intimidation statute. And there was no grand jury convened, so there was no grand jury for her to be testifying in front of. So I urge you to go and watch that, including the one about the couch that is alleged to have been purchased for not so confidential informant Kate Peter by Jennifer McCabe. That's in there too. And we read the affidavit. There's just so much here that it's hard to even summarize it for you. The witnesses that are on trial here that Aidan has been accused of intimidating are, there's a link in the show notes below to the Commonwealth versus Aidan Kearney playlist. Hold on. Let me guide you. I'll guide you there. So underneath the show notes, I have to mute myself because this is weird. If you're on a laptop, this is my laptop that I'm going to show you, so it might be different from what you are watching. So here's the show that we are currently watching. Hello. And then if you close out the chat, there's show notes right below. So they give you a nice little donate to Turtleboy's Defense Fund. And then it says catch up on the case here. And then you can click here on this link and it will take you to the playlist. Commonwealth versus Aidan Kearney, aka Turtleboy, and everything in chronological order. All of the hearings and stuff that we've covered. Wow, there's a lot of videos. There's 17 videos, but they are titled. There's Bederow's debut when he first appeared in court. That goes all the way back to, that was 9 months ago. Bederow Letters Part 2, Part 1. There's a lot of coverage. This one here, the one with the red thumbnail, says it's called More Karen Read Insanity, a sectional Iraq and a McCabe ultimatum. Monday could be Fire on Acid, because, you know, I take pleasure in my stream titles. It's the one that looks like this, that's red, where it says The Untouchables exposed Jen McCabe's ultimatum to DA Marcy, because this witness told Bradl, who wrote the affidavit, and Bederow, that Kate Peter told her, Jennifer McCabe said, unless Aidan Kearney's in jail, I'm not going to testify in the Karen Read trial. Like, it is deep. It is deep, and it is crazy. Good. So you can watch all of those later, and be sure to like them all and comment on them all. The Vanity Fair article is on X and not behind a paywall. Okay, who posted it? I'll go there, because, you know, I was also interviewed by Vanity Fair. Am I in that article? Because Julie did also interview me. Who tweeted it? Is it Vanity Fair that tweeted it? Let's see. There's been a lot of booing videos about Michael Marcy. I don't know if he was booed at the 4th of July parade, but, you know, he does get booed out a lot. And some of those are old, so I just don't know. Okay. Julie Miller. This was just published today. Oh, it's going to be story time, everyone. You ready for story time? Let's do story time. Julie Miller interviewed me as well. I spoke to her a while ago, months and months ago. So I don't know if I'm in it, but it's okay if I'm not, because I'm not here for notoriety. I'm here to shine a light on the damn truth. You can't handle the truth. And there's still 15,000 watching, so yeah, hit the like button and let's listen. It's going to be story time. This is an article in Vanity Fair published today by Julie Miller, July 7th, 2025. She is also the one who spent 3 days with Karen Read, and she wrote very positive articles about Karen Read, and she's very nice. And I spoke to her on the phone at length for a very long time, and I like Julie Miller a lot. Julie Miller is awesome. Karen Read's defense attorney talks. We brought to light some very uncomfortable realities. Alan Jackson takes Vanity Fair behind the scenes of the trial, from the not guilty verdict to his withering cross-examinations to what comes next for his headline-making client. There's a great photo of Alan and Karen outside the courthouse the day she was acquitted. Oh, what do you mean? It's not in front of a paywall. It's behind a paywall. When Alan Jackson walked into the Dedham, Massachusetts courtroom 2 weeks ago to learn the verdict of Karen Read's second murder trial, he was supremely confident his client would be cleared of all the major charges against her. And then they want me to sign in. Let me see if I can find it. Or if maybe I did subscribe, but I don't know. That picture is great, isn't it? All right. Thanks, Vanity Fair, for nothing. All right. This one's not behind a paywall. Maybe. Let's see. Let's try this again. Take two. Back to one, everyone. Back to one. All right. Take two. There's that awesome picture. When Alan Jackson walked into the Dedham, Massachusetts courtroom 2 weeks ago to learn the verdict of Karen Reed's second murder trial, he was supremely confident his client would be cleared of all the major charges against her. Reed, a former equity analyst, was on trial a second time for murder, vehicular manslaughter while operating under the influence, and leaving the scene of a collision resulting in death, charges stemming from her boyfriend John O'Keefe's death on January 29th of 2022. Based on the evidence and the presentation and the defense we put together, it was not going to be guilty. It just couldn't be, said Jackson, who represented Reed alongside David Unetti of Massachusetts, Elizabeth Little of California, no relation, Robert Alessi of New York, and Victoria George of Massachusetts during the second trial. Jackson's prediction held true. Reed was found not guilty of those three charges. She was found guilty of a lesser charge, operating under the influence of liquor. 1 second. Reed spent her life savings, including the sale of her home, on her defense, which she expanded after her first trial ended in a hung jury last summer. Some of her lawyers worked pro bono, as did the 9 law clerks who joined Reed's team for the second trial. Jackson estimates that his firm alone, where Little is a partner, would have billed $10 million for both trials. His firm alone would have billed $10 million. Wow. If the court even hinted that she was going to give her custody time and make her perp walk out of that courtroom with a guilty on the OUI, we were fully prepared. And Karen was prepared. She was buckled down for the possibility that Judge Beverly Cannoni would give her a year of jail. Had that been the case, Jackson said, we were going to immediately appeal it. See, I said the same thing. I was so nervous because we know they wanted Karen locked up for any amount of time. Cannoni and Brennan agreed that jail time was not necessary. Reed was sentenced to a year of probation. So crazy. Says Jackson, the first thing that flooded over me was, it's over. This odyssey that Karen's been going through, that I've been through, it's done. Jackson first spoke to Reed in late 2022 when she reached out to the high-profile defense attorney knowing that she could not afford his rates. He had successfully prosecuted legendary rock producer Phil Spector for murder in 2009 while working for the LA District Attorney's Office before he pivoted to defense. His clients have included pro athletes, royalty, and embattled Hollywood figures. Harvey Weinstein and Kevin Spacey. Reed initially hoped to get guidance on obtaining cell phone information, but Jackson asked to hear more about the case. She was being charged with fatally plowing her Lexus SUV into O'Keefe and leaving him to die. But O'Keefe's autopsy photos showed what Reed believed to be a dog bite on his arm and no bruising below his neck. It just didn't smell right, Jackson told Vanity Fair last year. I knew pretty quickly some other forces are at play here to point the finger at her, he said, and it's because those forces want to point the finger away from somebody else. The defense's investigation and a federal probe uncovered destroyed cell phones, a suspicious late-night Google search, a curiously relocated dog, and shifting stories from prosecution witnesses. During the first trial, Reed's team put together a defense around their theory that some combination of Albert, ATF agent Brian Higgins, and Albert's nephew Colin were involved in O'Keefe's death. All 3 men deny any involvement. After the trial ended with a hung jury, though, Reed's team pivoted to a Bowden defense. When Reed's second trial began in April, her defense argued that law enforcement's investigation into O'Keefe's death had been so poor and myopic that the agencies did not even interview certain witnesses, let alone consider other suspects. Wow, look at this picture of all of them at the defense table. This was in the big courtroom, so it was a long time ago. Alan Jackson without a beard. That's a great picture. And that's from, well, it doesn't say when. You can tell by the facial hair and the highlights when it was done. During the first trial, Jackson subjected the case's lead investigator, former Massachusetts State Trooper Michael Proctor, to a withering cross-examination, eliciting testimony that Proctor had the case wrapped up within 16 hours of starting it, before even setting foot on the crime scene. This past March, Proctor was dishonorably discharged from the Massachusetts State Police for misconduct on Reed's case. Proctor is appealing the decision, according to his lawyer. Anybody think he's going to be reinstated? Rather than call the disgraced detective to the stand, Brennan, notably, omitted him during the second trial. You were so embarrassed of Michael Proctor, you couldn't even put him on the stand, says Jackson. Brennan withheld other key witnesses from testifying as well. I thought it was a glaring error on the Commonwealth's part not to call certain witnesses, including Brian Albert and Brian Higgins, Nicole Albert, Matt McCabe, Chris Albert, Jackson says. They didn't want them to be subjected to a very vigorous cross-examination because the Commonwealth knew they would not withstand it. Do you remember? I'm going to break for a second to tell you that when David Yannetti and Bob Alessi came on my channel and we did an interview or a conversation, really, David said he spent 100 hours preparing his cross of Brian Albert, 100 hours. And then he posted on Twitter yesterday a picture of the table with all of his prep work for Brian Albert. And he said he was really mad they didn't call Brian Albert because he was so ready to cross-examine him. That would have been a full-throated cross-examination. Cross-examinations are Jackson's favorite part of a trial. I want the jurors looking at me to see the look on my face, my body language. I want them to listen to the tone of my voice and then turn back around and watch how the witness reacts. That is the fun of a trial. A good, solid, well, it says sold, but a good, solid cross-examination, it should say. And it requires an enormous amount of preparation. Every single question I ask is highly scripted because I'm building to something else. It's like a symphony. It's a beautiful thing to execute. I'll break to say that it is also a beautiful thing to watch, isn't it? Beautiful thing to watch. When he did his interview with Turtleboy on Saturday night, which I highly recommend, go watch it. Alan Jackson did. Aidan said to him, don't you get like, what did he say? Wait, I can't remember the exact quote right now. Don't you get afraid? Don't you get intimidated sometimes if the judge acts a certain way? And he said, I don't get intimidated. I intimidate. Something such as like that, right? It was awesome. And he did say every single thing that Karen Reed ever said or anybody ever said in this case was scripted. And I thought that too. Nothing was by accident. Nervous. Oh, I don't get nervous. I make people nervous. Okay, that's what, don't you get nervous? Yeah. And he said, I don't get nervous. I make people nervous. Right. Thank you. Thanks, you guys. And you can see the pleasure that he takes in it. And for all of you law students watching, I mean, Alan Jackson, Bob Alessi, David, all of them, masterclasses in direct and cross-examination and the handling of expert witnesses and oral arguments and so many other things. When I became a lawyer all the way back in the olden days, there was no place to watch trials. You had to go to court and watch trials. Law students today have an incredible advantage by being able to just go on YouTube and watch the best in the business do their thing. An amazing gift. I don't get nervous. I make people nervous. The lawyer realized his cross-examination skill set during Spector's 2007 and 2009 trials. Vanity Fair's Dominic Dunn was impressed enough with Jackson to describe him in this very magazine as a courtroom orator with a theatrical flair. Because of Spector's deep pockets, Jackson faced off against the country's best lawyers and experts, including forensic scientist Henry Lee and forensic pathologist Werner Spitz, who worked on world-famous cases including the JFK and Martin Luther King Jr. assassinations and the O.J. Simpson case. That's when I realized I'm good at this, Jackson said. Nobody intimidates these guys, but I was able to not just hold my own. I was able to, I don't want to use the word defeat, but you can certainly win an argument. Jackson gauges juror reactions in real time to inform his cross strategy. You have to earn certain things from the jurors. The jurors have to want you to scream at a witness before you scream at a witness. They have to want you to laugh and be sarcastic with a witness before you laugh and are sarcastic with a witness. That's great advice. While cross-examining MSP Trooper Yuriy Bukhenik, Jackson stepped away from the podium to grab a document while Bukhenik was answering. Are you listening? Asked Bukhenik. You asked the question I wanted to answer. Jackson retorted, I know the answers. to all of my questions. We loved that moment, didn't we? I remember that moment well. The jurors all chuckled, said Jackson, and I just struck a stake through his heart. You have to be really comfortable in your own skin to be able to have an argument and know that you're going to win it in front of a jury and national television too. The Texas-raised Jackson has looked to lawyers on screen for inspiration. It was Perry Mason growing up, but Tom Cruise's Lieutenant Caffey in A Few Good Men remains the exemplar. Jackson, who went to college on the GI Bill before graduating from Pepperdine University School of Law, mainlined the Rob Reiner directed film during Karen Reed's first trial. I've seen it so many times and it gives me such a boost, he says. Now Jackson and Reed are entertaining Hollywood offers themselves for a book and a scripted adaptation of the case Jackson considers the magnum opus of his career. Oh my God, how many times during the trial did we want him to say, you're out of order, you're all out of order, or no, you can't handle the truth. That was from A Few Good Men, right? You can't handle the truth. I doubt that there's a judge in Massachusetts who hasn't in some way been affected by the Karen Reed trial. This is a quote. I doubt that there's a prosecutor, a defense attorney, or even a potential juror who hasn't been somehow affected. We brought to light some very, very, very uncomfortable realities about the Massachusetts justice system, and those realities need to be addressed. Asked for an update on Reed, Jackson says, quote, as much as she is relieved and elated and so very, very thankful to all of the people who have given her who have given her undying and unyielding support, it's been an unbelievable amount of stress for her to deal with for the last 3.5 years. And it's not like a light switch. You can't just turn that off. End quote. Before he left Boston, he says he warned her, quote, you're a different person coming out of the back end of this thing than you were going into it. And it's going to take you a minute to figure out what the new normal is for Karen Reed. Great article. That was published today by Julie Miller. Props up to Julie Miller in Vanity Fair. Well done. And I knew, and I had a feeling, because Alan knew that he had an open invitation to come on my show whenever he wanted, and had a feeling that he had a media plan and he had first look deals. And we're learning now there is a movie or a TV series in the works by the same production company that did Killers of the Flower Moon, which is a Scorsese production and was nominated for lots of Oscars. It came out in 2023. I tried to watch it. I'm still watching it. I'm still getting through it. It's 3.5 hours long. And it's slow. And it's Leo DiCaprio. And it's a very interesting story, but it's Scorsese. And if they get Scorsese on this one, it's going to be big. It's going to be big. Hi, Nina. Do we know anything about the new chief of police? Is he good? Or just like Berkey Rafferty, at least he didn't promote all the liars? I don't know. I don't know anything about the new Canton PD chief. Maybe somebody in the chat can help you out. Just another snowplower says, I'm a witness to an effed up trial and dumbass BS. Thank you. Thank you for your super chat. Dennis the Menace. July 7th, 2005, were the mass bombings on the London Underground 52. Killed 770, injured UK, 9/11. I am British, living in Canada. Very sad day. Very sad day. Thanks, Kay, for becoming a member. And Stephanie for becoming a member. And West Virginia for becoming a member. And Melissa says, so happy to be here with you in the chat. Thank you. Yeah, you're out of order. You're all out of order. Is from the Al Pacino film and Justice for All. Thank you, Joe DiMartino. Because as soon as I said it, I'm like, yeah, no, that's Al Pacino. That's not Tom Cruise. Wait, what did Tom Cruise say? It was Jack Nicholson who said, you can't handle the truth, right? And am I clear? Crystal. I'm going to go watch that movie again. Demi Moore is in that too. Boy, does she look amazing. I want to know who her plastic surgeon is, because nobody looks better right now in Hollywood than Demi Moore. And I forget how old she is, but it's a lot older than you think. Thank you, Melissa, for your sweet compliment. Leandra says, Yanetti's notes on Chloe had information on Malinois breed, which mixed with German Shepherd are a huge liability bite-wise. Yes, you know who he probably learned that from? Perhaps, maybe Garrett Wing. Because Garrett Wing has a YouTube channel. And he does a lot of training on the Malinois. Correct? Correct. I believe so. And Needham wants to know, will McAlbert's testify in this case? They're witnesses. They're going to have to. They're going to have to get on the stand, and they're going to have to talk about how they were intimidated by Aidan Kearney. I mean, if you're going through the playlist of my streams, look at the decision on the motion to dismiss, because I read the entire decision. I forget how many pages it was, over 30 pages. There's a lot of detail in there about what the allegations against Aidan Kearney are. Remember, allegations do not make them true. It is just what the judge had to consider during that motion to dismiss. And so it talks all about the charges against him and the 6 that were dismissed, because I think there were 16 in the beginning. Right? So there's that. I've been invited somewhere and I'd like to take you guys with me, okay? But I need to redirect us over there so we can all go together. Yes, Trooper DiCicco was removed to Holden per Howie Carr. He was in a proctor test. That is correct. You are correct about that. 100%. We read that earlier. So hang on so I can redirect all of you so you can all come with me. Whoa ho, what I want to know. Will you come with me? You want to come? We're going to a secret private fundraiser for Aidan Kearney. We're going on a field trip, everyone. We're going on a field trip. Everyone get ready. Thank you, Lyndon, for becoming a new member. And some of our friends are there too. We're going to go over there because not Aidan. It's Nick Staro's channel. Andrea Burkhart is there, and the Glairer is there, and Mike Crawford is there. And it's a fundraiser for Turtleboy that he didn't know anything about. So as soon as I hit end on this stream, we're going to go over there and we're going to surprise them. And hold on, because they have, let's see how many people they have watching right now. 800 people. And all of us are going to go over there. We're going to surprise them because we have 14,000 people. Are you ready? And we're going to raise some money for Aidan Kearney, okay? Buckle up, buttercups. Here we go. I'm sending you there in 3, 2, 1. Safe landing.